name's Richard Wells. I'm a partner at Minter Ellison Rudd Watts, and with me is Susan McMillan, who's a senior associate in our privacy team here. The topic of today's webinar is busting the privacy myth that every breach has to be reported to the Office of the Privacy Commissioner. While some commonly believe that every breach needs to be reported, obviously the reality is slightly different to that. Only certain serious breaches are mandatory to report, depending on the level of harm that they will or are likely to cause. So by the end of today's session, we're hoping to clear up some confusion on when breaches should be reported. And we're hoping that we're going to help agencies to make more informed self-assessments on any privacy breaches that might occur. Obviously, we're not going to be treading any line that privacy breaches are not important, and maybe you should err on the side of caution. But we want to present a balanced approach so that you can properly assess when you need to report and maybe when you don't need to. So, Suze, perhaps you can kick off with telling us a bit about what's a privacy breach.
Yeah, sure. So yeah, just stepping back, I'm sure everyone on the session today understands that under our Privacy Act that came in 2020, there is a mandatory privacy breach reporting framework in place. And I guess the first start of making that assessment as to whether you need to make a report is to determine if a privacy breach has occurred. So the Act sets out what a privacy breach is, and it's essentially any unauthorised or accidental access to, disclosure, alteration, loss, destruction of personal information. And it also includes any action that prevents the agency from accessing information, either on a temporary or a permanent basis. So things like ransomware attacks are also covered now. And the important part here is that a privacy breach doesn't have to be intentional. It can be accidental and still fall within that definition of a privacy breach. So some common examples that we see privacy breaches occurring are things like sending information to the wrong person, entering the wrong email address, or it may be physically posting a letter to the wrong person, or calling the wrong person on the telephone as well can be a privacy breach if you're giving away personal information. There's also things like employee browsing, which I think, happens more than we would like to think. Employee browsing without proper authorization and justification does constitute a privacy breach, even if the information doesn't actually go any further than that employee that's having a little snoop around. Also, if you have any devices, computers, laptops, USBs that are lost or stolen, or if they're disposed of without proper destruction processes of the data that's contained on them. And then also there's obviously what we alluded to before, which is that ransomware. So an agency, losing the ability to access their personal information. And this is one of the biggest areas where we often get involved is large-scale cyber attacks or ransomware, or just people hacking into your system and stealing or deleting data. So there's a real range of privacy breaches, and they do vary in terms of the scale and complexity of them. So once you have discovered that there is a privacy breach, you then need to determine if it meets the threshold for being a notifiable privacy breach, which is when the Act kicks in and you have reporting obligations under the Act. So when we look at whether a breach is notifiable, there is no specific definition in the Act as to whether that breach is notifiable. You have to look at a range of factors which look at whether the breach is likely or has caused or is likely to cause serious harm to the individuals affected. And this isn't a clear-cut kind of assessment to make. It's great that there's factors to consider here, but each individual case needs to be considered on its own merits and its own facts. So the Act does sort of set out some very important factors that need to be considered. And in Section 113 of the Act, they do list those out. So maybe Richard and I can just go through some of them in detail and kind of give you a flavour of the level of complexity that often comes into these assessments, because it's never just one factor, it's multiple factors that come to that decision.
Okay, so should I run through a few of those, perhaps, Suze? So harm includes physical harm or a threat of that, financial fraud, obviously, and psychological harm. And as Susie mentioned, Section 113 talks about the criteria that an agency needs to consider when assessing that harm to decide whether it meets that high threshold that is serious. So when you're looking at it, it's about a likelihood that there is that the harm has occurred. So often when we've been approached to make these assessments, people think that as soon as they've identified a breach and that some of the factors might occur, that you're automatically in a situation where you're dealing with serious harm. The serious harm actually needs to be likely or have happened. And when I think about likely from a legal perspective, that means that there's more chance that it's going to happen rather than it's not going to happen. So I suppose just looking at it on a percentage terms, you'd have to say it's more than 50%.
Yeah, it can't be remote.
No, exactly.
I mean, in every case, there could be a remote chance of harm occurring.
So then you step through some of those factors that are within 113. So the first one is really, are there steps that the agency's taken to reduce the risk of harm following the breach? So typically when you're working through what the OPC sees as best practice, the very first step that you need to take with a breach is that contain phase. So what have you done to contain the breach? Have you been able to head it off at the pass by either ring fencing the personal information that's been made available? Have you been able to shut down systems? Are there other steps that you've been able to take to ensure that the risk of harm is contained effectively? So that's a factor that is the first one that you need to work through.
Yeah, and often that containment phase requires some external assistance because, I think organizations, when they find out there's been a breach, often don't have the capability to properly contain that because, yes, you need to shut down the systems that are compromised, but in doing so, you may inadvertently lose, evidence or, you may lose the data yourself in doing so. So there are very careful considerations that need to be made in that containment process, and often having specialist IT experts is the way to go before you make any rash decisions on that point.
I think so. And then the next one is important because the next criteria for assessment is looking at what is the type of information that is contained within the breach. So the level of sensitivity of that data. And obviously personal information falls on a spectrum. At one end of the spectrum, you have personal information that it's relatively anodyne, maybe name, maybe email address, and then you're sort of building up a gradient from there, phone number,
physical address,
and then more specific types of personal information, ramping up to things like financial information, sensitive, health information, incredibly sensitive. So placing the type of information that's contained within the breach within that spectrum will help assess the likelihood that it's going to be serious. And obviously, the more sensitive, the more serious harm that can take place. And I think often when we're talking about health information and financial information in particular, if very specific pieces of information, personal information containing that type or that category is part of the breach, really you're starting to head down a route where it's going to be difficult to make an argument that you don't need to notify. I think let's be honest about that.
Yeah. There may be exceptions as to when that information may have gone to a trusted third party, for instance.
Yeah.
But yes, if you're looking at larger scale breaches that involve that type of information, and you have a potential threat actor involved or a malicious actor involved in the breach, then certainly yes. Also things like passport information, driver's license, if any of that's released, particularly if it's a photo or the full details, that's very sensitive, and can, clearly cause harm to an individual.
I think when we're talking about the different steps, obviously you go through the contain phase, then you move to the assess phase. And the assess phase is something that you can conduct yourselves, if you have the right access to your system. So categorizing the different types of information, so that you understand what it is, basically, and then figuring out, making your own assessment about the level of sensitivity that is attached to any of that will help with that assessment.
The tricky thing is when you have a breach that involves your entire system or a number of databases, there will be different data sets within different systems and databases. So when you're looking at the type of information involved, some data sets may be anodyne, but some may contain more serious sensitive information. So it's not a one size fits all when you're making the assessment as well. You'll have to maybe deal with different data sets differently, or when it comes to a wide scale breach, you may decide to treat everyone the same, no matter what kind of bucket they fall in terms of the affected information. So that's another thing to keep in mind. And
we were going to talk about that a bit later.
Yes.
Okay. Let's not get ahead of ourselves. Okay. So maybe you can talk about the nature of the harm, because that's one of the other factors. So the type of harm that could be caused to affected individuals.
Yeah, and I think this is actually related to the point before, because the nature of the harm that could be caused is important. So if it is financial information and your identity information together, that will raise the likelihood of there being, financial harm or identity theft being caused to those individuals, and therefore, the nature of that harm is much more serious. So it's kind of a combination of the two. If we're talking about just having your email address, published online, well, yes, that can be distressing for people, but in reality, the nature of the harm that could be caused by that is relatively low. And I think that in an online world, you could probably Google somebody and find out their email address pretty easily anyway. So we have to look at the nature of the harm in terms of what will it actually cause for the individual, not to discount people's emotional stress at being involved in a breach, but obviously risks of physical harm or financial harm are much more serious to consider than just being distressed about being caught up in a breach.
Yeah, fair enough. And then the next factor I think that's worthwhile looking at is who the information has gone to. And let's face it, in many situations, you've got absolutely no idea, particularly if there's been a threat actor, or TA as we call them now. If a threat actor has come in and hacked your system, you don't know where that information has gone. So obviously that creates additional risk to the scenario and might mean that you have a likelihood that there could be a serious harm arising. At the other end of the scale, though, and I have to put my hand up and say that I'm one of these people, I have sent information to the wrong recipient on a number of occasions. And in that situation, if the recipient of the information is, for instance, another client, or someone that you know, or a customer that you have maybe a contractual relationship with, I think, and if you've acted quickly in order to notify them, to ask them to delete, and have received some form of confirmation that they are willing to do so and have done that, I think that really does assist to lower the risk and perhaps push you more towards a situation where you're not going to need to notify. Really, it's the malicious, unauthorized recipient, the non-disclosed recipient, the recipient that you can't identify,
or just somebody that's unknown. I mean, if you sent health information to the wrong patient, that person could just feel aggrieved that they've received this and have concerns, and then kind of take it more further, or they can make complaints. Or so there is an element of sort of understanding who they are and having a trusted relationship is important. And so the final one there is probably also whether the information is protected by a security measure. And so this is, if you've got a USB and it's encrypted, then losing it may not be as serious as you might think. Or if you've got a hacker coming into your system, yes, they might be able to access the systems, but if the database is protected by encryption, then they won't be able to crack into it and actually access the data. So although you have a breach situation from a security perspective, the data, you can be rest assured, is still safe, and therefore you may not meet the threshold in that case.
I think there's been some good guidance here from the OPC. So would point you to that. I think the OPC has been very clear over the years that sensitive information needs to be encrypted at rest, and we certainly recommend that. It's something that is becoming easier and easier and easier to do, and is being seen as best practice. So we'd recommend obviously that encryption at rest if that is something that your organisation's able to look at.
And I guess in transit, if you're sending PDFs of personal information, make sure that they're password protected and that the passwords are sent via separate email. So it sort of goes to your IPv5 responsibilities in a way. If you're an organisation that deals with personal information and you're sending it or storing it, then you really need to make sure that your IPP obligations are met in terms of protecting it.
Okay. But then there's this other bullet point, which is other relevant matters. And so what are they? Well, of course, it's just what the situation demands. I think the first one, though, and the point that we often come across is how large is the cohort of individuals affected, and what's the nature of that cohort? So is it just a database relatively small, or is it massive? Are there children involved, or is the personal information relating to children or people that are vulnerable? I think that is an important consideration that needs to play out. I think that while there hasn't been any specific guidance, I could be wrong on that. If you have relatively anodyne personal information, but the number of people who are affected is enormous, I think it's going to be very difficult to make an argument that that you're not in a notifiable situation. But again, it's a bit of a sliding scale.
And I guess that comes down to the point that, when we're looking at whether serious harm is likely or not, the larger the cohort, the larger the possibility that some harm could occur to some of those individuals, because every individual is different and every individual will experience different harm necessarily. So yeah, bigger the cohort, the bigger the risk there.
And then I suppose another point is the extent of the breach. So has the information made its way onto the dark web? Has the information been offered back up? Has the threat actor come forward and demanded a ransom? Those sorts of elements, I think, are very important. And certainly in a situation where there is a threat actor who's demanded a ransom, I think that's a clear indication that you're dealing with a potential serious harm scenario that would need to be notified.
One of the other factors is, whether the information could be paired with other information that's maybe publicly available. So only a subset of personal information might be disclosed, but could they then use that information, Google the person and find out other information about them and could try to, create harm that way? I think that's also, you can't do that on an individual basis necessarily, but it is something to keep in mind as well.
Yeah, and maybe another one that we've noted here is what actually caused the breach. So was it carelessness, poor practice on part of the agency, or was it actually a threat actor coming in? All of those factors do go into play within the assessment. But just to roll it all back, that other relevant matters is something that I think just will emerge with your advisors when you're assessing one of the or the relevant criteria. So we'll find over time, I think, that list of other factors that we've talked about will grow with practice and with with examples that are released into the public domain. But I think it's important to remember that the serious harm in all cases needs to be likely to occur, so more probable than not. Okay, so I think we've got to a point where we can assess, and then if you've met the threshold, Suze, what do you need to do to report?
So once you have determined that you have a notifiable privacy breach, the Act requires you to report to the Privacy Commission, the Office of the Privacy Commissioner, as soon as reasonably practicable after you discover that there is a notifiable breach. And the OPC's guidance indicates that they expect to be notified, within 72 hours. But the question, and we often get asked this from clients, is when does that kind of 72-hour timeframe kick in? Because when you first find out about a breach, you don't know the extent of it. You don't know if it's a minor breach or it's more serious. And so you do have to do some assessment before you can determine whether it is a notifiable breach. So our view is, and I'm not sure if necessarily this is accepted by everyone, but that 72-hour timeframe does not necessarily kick in at the first moment you discover a breach. I think that there does need to be some initial investigations, not a complete investigation, but there does need to be some initial investigations done before you determine that potentially a notifiable breach has occurred. And that's when that 72-hour time frame will kick in. And I think that that's got to be the case from a practical perspective, because these things are not easy to deal with quickly. I think that they can be, your priority is to contain it first, and then the assessment time, aspect of it kicks in. So there's a lot going in those early hours of a breach. And I think that people often get very concerned early on about making a report as soon as possible. But I think you do need to step back and just take a moment to do an initial assessment. If it's looking like it's a large scale breach and there is likely to be, sensitive information involved, then yes, you're going to discover quite early on that it's potentially notifiable. But I do think we just want to caveat that with the fact that there does need to be some caution there.
But can we just work through an example then, maybe? So let's just say, because these things normally seem to happen on a Friday.
Yeah.
So 5 p.m. on Friday. Actually, no, let's make it 6. So 6 p.m. on Friday, you get told, oh no, there's been a problem. You're saying that the clock doesn't start ticking at that point. So you're entitled to work to contain. And then maybe over the weekend, people are thinking about, factors that we had before.
Yeah.
And
actually just discovering what information is impacted. Yeah.
Yeah. And maybe asking for legal advice to confirm whether the breach is serious. And so would it be the time that you've firmed up your call that it is serious? So say you figure that out on Monday morning, is it 72 hours from that point that you'd really want to be notifying?
Technically, that's my view, but I think you'll probably have an idea that once you have an idea that you've done that assessment, you're going to be pretty prompt in making that report, right?
Yeah.
So yes, the 72 hours would kick in from then. But I think realistically, you'd be able to report before then anyway, because you've spent the weekend gathering that info, right? You understand, you're just confirming the legal position, you're confirming with your IT experts. So you're going to have a good picture.
Yep.
And it's worth noting that in that initial report to OPC, you don't have to have all the facts at that point. So it's an initial, preliminary, notification, so to speak, that yes, based on the facts we know as of today's date, we think that this may constitute a notifiable privacy breach. So you can drip feed information as you go. And I think it's worth pointing out that this view on the 72 hours doesn't mean you can kind of just sit there and do nothing till Monday morning.
No.
And then start to look into it. You do need to be, proactively engaging as quickly as you can.
Well, I think that's one of the important points, isn't it? Because inevitably, if you are notifying the OPC, you're going to be notifying affected individuals too. And one of the first questions that comes back, particularly if it makes it into the media, is, have you notified the OPC? When did you do that? When did you first discover the breach?
Yeah.
And if your timeline looks like you've perhaps taken a little bit too much time around that contain and assess. It can play in multiple, media cycles, which, certainly from an agency's perspective can be challenging. Looking at it from an affected individual's perspective, it might be helpful if they're receiving that information and, the agency's been placed on a little bit of pressure there.
Yeah, absolutely. And just on the reporting point, the OPC has a really good online tool that you can use to make your report. But what we've often found with clients is that there's quite often a lot of nuance and complexity or context to a breach. And yes, there are free data fields in that reporting tool, but often we find that a letter accompanying that report is quite useful just to set the context of what we know so far and what we're doing going forward. It's about putting that narrative together as to what you're doing and what you've done. So just keep that in mind when you're reporting, that you can report in multiple ways.
Yeah. Okay.
So if it doesn't meet the threshold, should you still report? What do you think?
Oh, okay. So obviously reporting's not mandatory if you don't meet the threshold. So, if the data's gone to a trusted person, or if it's been deleted, or the information's mundane and you've come up with a reasonable justification for that. So in that scenario, you might choose not to report. Of course, you do run a risk in that scenario that if you've made a borderline call, that it ends up in the media and you're asked, and the OPC gets hold of it and you're asked to justify why. In that scenario, if you have failed to report a serious breach in the OPC's assessment, you can be liable for a fine of up to $10,000. I'm not aware of any fines that have been given under that so far. No. So I think
you have to have deliberately failed to notify. So if you've taken some assessment and you've come to a decision based on reasonable grounds that you don't think it's notifiable, I think in most cases you would be excused from a fine. But that's not to say that there won't be one in the future.
No, true. And I suppose if you're uncertain about potential harm, then you could choose to report and then confirm later with the OPC that despite that, in your view, the reporting was made, but you've made an assessment now that the breach didn't reach the serious harm threshold, and see how that plays out. I mean, obviously in a breach situation, the facts change rapidly over time, and depending on the way that the investigation is run. So there could be a situation where it first appears bad, or maybe a little bit worse than you expect, but then it turns out the data is protected. From my experience and Suze's, that's an unlikely scenario. It's normally sadly the other way around, where there's underreporting to begin with, and then the number of people affected dramatically increases, the extent of the harm dramatically increases, and so on and so forth.
So are we getting to a point where you think that if it's borderline, you should report?
I think that would be my advice.
Yeah.
I think that you really need to be in a clear-cut scenario where you're right at the low end. It's just a far safer option to report and be transparent. And I think also to work on your corporate license and be a good corporate citizen by doing that, and also engaging with your client base. I mean, in our experience, we've found that the way that you approach these breaches and the comms with your customers is pretty binary. If you engage well, you're transparent, you have clear facts, and you communicate them in line with your obligations, you can, despite the difficulty, get through and enhance your customer goodwill. On the other hand, though, if you're constantly having to revise the information, if it's incorrect the first time you go out, if the investigation turns up multiple problems and you just aren't reporting in a clear, transparent way, the result is often bad, and you lose goodwill with your client base.
And that's probably a good point to raise, Richard, is you're reporting to the OPC is more time pressured, I assume. You want to get that report to OPC as soon as possible. But you may want to take a little bit longer to report to individuals because, as you say, if you get the comms wrong to individuals, it can make the situation worse. And so, yes, you can drip feed information to OPC, which is great, but you don't want to be drip feeding information to customers or individuals because that just causes more worry and concern, and you don't want to have to backtrack. So I think it's important to prioritize that OPC notification, and then you actually might want to have a discussion with OPC about how to communicate with individuals. They're great for engaging on that basis. And also just get your facts in order, make sure your IT guys are very confident about, what information has been affected and what we're doing, etc., so that you have a very clear picture when you do go out to individuals.
But if I am trying to make an argument about, when you wouldn't report, I mean, I suppose it would come down to maybe a risk that in some situations you over-report. So you're telling someone about something they don't really need to be worried about at all, just out of an abundance of caution. And in doing so, you make people a little bit more anxious about a scenario that they don't need to be. So I suppose in that situation, over-reporting could also damage reputation and erode confidence. And it might mean that you experience more regulator scrutiny into what has actually happened than has actually been the case as well. So it chews up, valuable management time, valuable IT often time in responding to OPC requests if they are trying to determine whether it was actually serious enough.
Yeah, and they have a lot on their plate. So
yeah, I mean, I think that also putting a hat on as a director, if you just go through and report straight away as a trigger without exercising due skill, care, and expertise and being curious about what's happened, I mean, there is an argument that you haven't really discharged your director's duty correctly, in that you haven't taken into account relevant factors before making an official regulatory response. So from a director's perspective, I think over-reporting also, I mean, it's a minor concern, but I think, worthwhile thinking about making your decision based on clear, substantiated facts rather than just doing a trigger in order to get to tick a box.
Yeah, absolutely. So then I guess the question is, if you decide not to notify because you don't think it meets the serious harm threshold, what do you do? And in our view, which we always recommend to clients, is to make sure that you document that decision and the reasoning behind it very clearly, and make sure that it's actually goes to board or management level and gets appropriate sign off. And I think, all breaches should be recorded in some form in a breach register held by your organization. And that will help, if the OPC does happen to come to you and say, hey, look, why didn't you report? Or, if they have other concerns and they want to look at your systems and processes, you can show them that assessment. You can show them, your reasoning, and show them a record of what breaches have occurred. Also, when you do encounter a breach that hasn't necessarily met that threshold, that's kind of not the end of it, because you've still had a privacy breach, right? And so there are still things to do, just because you don't have to breach, there are still things like undertaking risk assessments about your systems. For instance, if you've had a number of, auto email correct, email addresses going to the wrong place, there may be there's something in your systems that you need to look at to take out that autofill of the email address, for instance. So there's always opportunities to identify areas of improvement. There might be a requirement for more staff training on, sending documents elsewhere, or password protecting documents before being sent out of the building, those sorts of things. So, our view very much is, that's not the end of it when there is a privacy breach, even if it doesn't meet that threshold.
In terms of the documentation, would you recommend that the agency checks off against each of those serious harm indicators and sort of does maybe a chart, what that serious harm indicator was, what the response was, and what our view on, or what your view on the, whether it's serious or not?
Potentially, yeah. I mean, if it's quite a large breach, then yes, absolutely, you'd need to go through all of those factors and make an assessment. For smaller breaches, like if you've just sent an email to the wrong person and it's gone to a trusted advisor, you may not necessarily need to go through the whole process, but you still need to set out the facts, how it happened, why you have considered it's not serious against those factors, because it might just be, one or two factors that are relevant to this particular scenario. But you do need to, refer back to that assessment criteria in making your decision.
No, that makes sense. And I suppose in response to a breach, that's probably worthwhile as we're starting to wrap up, thinking about some of the practical things that agencies can have, so that they can respond appropriately in a breach scenario. And the OPC has always been consistent that it is contain, assess, notify, and then I forget the last one. The last one is about continuous prevent. So it's about this continuous improvement element that Susie just discussed. One of the things that as part of that continuous improvement process, though, is reviewing your breach response plan, having that in place, checking whether there were any elements of how you went in the past and reflecting those there, and then testing that plan. I think that running a test every year is a good standard. I know that many organizations do that, and having privacy, cyber, and matters relating to those on a board agenda, making it part of the governance as well as the operational requirements of an organization is absolutely critical, and part of what we talk about when we're talking about privacy by design, which is a catchphrase that's been, well, it's actually not a catchphrase, it's a system that's been in place for a long time to really drive great privacy behaviors. As part of that plan, knowing who to contact when something goes wrong is important. Mapping your data assets, understanding what information you have and where you might fit on a privacy risk threshold or spectrum, I think is important.
Definitely. I think that's one of the key difficulties that we've come across when helping clients with breaches is that there are databases in these systems that they didn't know were there or that should have been deleted years ago, like archived systems that have been sitting around not used. And so one of the hardest parts of doing that assessment process is actually figuring out what data has been affected. And so doing that data mapping exercise early on just makes it much easier for you if you do encounter a breach to be able to say, well, these are the systems, they're stored in these systems, we know where everything is. Yeah.
I mean, probably a topic for another time, isn't it? If we're getting into data retention periods, that's a fascinating one. But we typically find that people hold on to the information far longer than they have a real need for it.
And it's one of the most common complaints really that come out of breaches, do you think, from individuals is
I do.
Why are you holding my information?
And often it's just, we've just been adding to our digital lake of information over time. It's very easy. It's not like we have too many paper records anymore, so we're constantly thinking about, oh my goodness, where are we going to store all this? When it's digital, it just is another server or an extension to your service terms, and the information just grows and grows and grows. So figuring out when you need to get rid of it, I think, is a very important step, not only from a data response perspective, but also the less information that you have, the more contained the breach is going to be to begin with. So that's important too. Absolutely. I think we should probably wrap up.
Yeah, that was really, really useful. Thanks for joining me today, Richard. And thank you all for attending today's session. It's been great to be part of Privacy Week 2024. And I hope you've all managed to get along to lots more of the other sessions run by OPC this week. They've been really informative. I've really enjoyed them. So if you have any questions about today's session, please feel free to reach out to myself or Richard. We were very happy to be here, and we hope that you've got some takeaways.
Thanks, Suze.
Thank you.
See you all.
See you.